Good morning, everyone. I want to take this opportunity to discuss some anticipated changes in the upcoming administration. There are many policy changes. We've probably heard about these changes in the news, but I want to bring some clarity as well as provide us with insight as to what things you can do. This morning, we're going to be talking about um, the increased risk of deportations and detentions. We're also going to be talking about how criminal records, criminal histories can impact individuals, put them at increased risk for removal proceedings and deportation. We want to talk about solutions for those who have past criminal histories, the ability to clear your record, and also talk about reopening cases where someone has been removed before in the past. What can you do? Can I get a second chance? So those are things I want to talk about. Talk about how we were able to accomplish that. Next. So initially, our first topic is increased deportation risk. We've probably heard from the new administration that there's a likelihood of detention as well as increased deportation proceedings against individuals. And I want to talk about who perhaps is subject to those. Those most at risk for deportation and detention are those individuals who have prior removal orders. Now, it's possible that someone may have a prior removal order, but was never actually departed the country. So those individuals are at increased risk for detention and for deportation. And in light of that, there are things that you can do in order to see what my options are. Next. Additionally, I want to let's go back to the last slide. Concerning increased deportation risk, um, those individuals, those individuals who have criminal histories, prior deportations, are people who need to be particularly concerned. If you were placed in removal proceedings before, or you had encounters with immigration officials, it's extremely important that you consult with an immigration attorney to kind of know where you stand, to know whether or not there's an outstanding removal order and what you can do about those removal orders. Those individuals who are in the United States in violation of immigration laws also need to consult with immigration counsel to determine um, what perhaps my criminal history, how that impacts my immigration status, as well as if I have no status. Now, if there's a prior removal order, it may be possible to reopen those cases, but that's something that we would have to consult on a case by case basis. Next slide, please. Most importantly, the conversation from the new administration has been most focused on those individuals who have criminal records. The criminal records typically those people are going to be targeted for removal proceedings and also targeted for deportations and detention. Now, with criminal histories, there's a myriad of different types of criminal activity. It can be something as minor as a traffic incident or something more serious. However, even minor criminal matters can subject someone to immigration authorities and deportation proceedings. Not all, whether or not those criminal histories are something such as misdemeanors or felonies, is not primarily the issue, but it's the nature of the criminal convictions. I've in my practice, I assist people who have criminal histories to determine what is the impact on their immigration status if they have certain types of offenses. What type of offenses will most likely put them at risk, and what are remedies to overcome these issues. Many times when individuals suffer criminal convictions, it's because they've entered a plea to a conviction, and many times it's without fully understanding how those offenses will impact them. And we've been successful at helping them to revisit those records, clearing those records, or minimizing those records so that they no longer have criminal histories. Next, please. This topic right here, post-conviction relief. Post-conviction relief involves individuals who are non-citizens who have criminal histories. Post-conviction allows an attorney to go in and petition the court to redress or to revisit criminal history. For example, if you entered a plea to a conviction, but you didn't fully understand how that conviction would impact you, you may be able to clear that conviction from your record. I've been successful in doing that, and I've helped people to address those issues in immigration court as well as in criminal court to determine what we can do, how we can mitigate, how we can negotiate for offenses that don't have direct impact, and also how we can clear those from the records. Post-conviction involves reviewing one's criminal record, understanding whether or not at the time they entered the plea, they were able to understand the impact that it would have on them, and then asking the court to remedy that by clearing that from the record. In the new Trump administration, that there's been discussion that those who have criminal histories are going to be those where the main priority, the main focus is going to be. And so it's extremely important to speak with counsel, to look at your records, obtain your records, to understand to what degree that my history is going to impact me and what avenues of relief that I may have. Next slide, please. We've also encountered individuals who have prior removal orders. And with those prior removal orders, we're able to go back and look at those and determine whether or not there's been any changes in the law or any new relief that's available for individuals. Now, in order to reopen a case, we have to look at things as to why a person was ordered removed, whether or not there's been a change in the law, whether or not presently they have a fear of returning to their country, and whether or not they meet all the requirements to ask the immigration courts to revisit their removal order. Now, these cases present some challenges because with those prior removal orders, there's an outstanding order of removal, and the new Trump administration has indicated that those cases, those individuals who have removal orders will be subjected to possible detention and possible removal. So it's extremely important if you've suffered a prior removal order that you speak with an immigration attorney to determine, can I reopen my case and what relief is available for me now? If we can go back to a project, we can go back to the slide number 2, criminal records. I want to discuss that a little more. Okay. One of the central issues that I've discovered with criminal histories is that many times individuals are they've been convicted of crimes where they've entered a plea, but they don't fully understand the immigration consequences of that plea. Many times, an individual is asked to take some sort of probationary action, but they don't understand that emission of that offense would result in an adverse immigration consequence, such as losing my immigration status or being ineligible to apply for a new status. What I've discovered is that once we look at the criminal record, we're able to determine whether or not they were properly advised as to the adverse immigration consequence. This is extremely important, particularly at this moment, because the Trump administration has announced that it's going to target initially those who have serious and violent criminal histories. Even those who have minor criminal histories are going to be at risk. The way that criminal records impact an individual is that it subjects them to being placed in removal proceedings. The solution for this is post-conviction release. If we can go to the next slide, please. As we see here, post-conviction relief involves an examination of the criminal record, an examination as to whether or not you fully understood the adverse immigration consequences, and also an examination as to how that conviction would affect you, would subject you to removal. In my practice, one of my focuses, in addition to immigration law, is criminal defense and post-conviction. With post-conviction, if you're able to convince the state court that you didn't fully understand the adverse immigration consequences of your plea, you can then ask the court to remedy that by clearing your criminal record or by mitigating that to a lesser offense. Lastly, I want to talk about motions to reopen. That's our last slide, if we can go to that. As I mentioned prior, the motions, individuals who have prior removal orders, I believe, are going to be most at risk. There's already a removal order that's been signed by an immigration judge or an immigration official. That could have been an expedited removal order at the time that you entered the United States. Also, it can be a removal order that was if through an immigration judge. And if you didn't leave the country when ordered, you will be at risk for being detained and then subject to removal. Now, there are statutory requirements to reopen a case. Those statutory requirements involve being eligible for new relief and also whether or not you have a fear of returning to your country. Many times at the time a person was ordered removed, there may have been changes in country conditions, which would allow someone to apply for protection, such as asylum. And if you believe that there's a risk to yourself returning to your country, that can be a basis of reopening your removal case. Now, time is a factor. If the removal order took place many years ago, you would have to convince the court that there's an explanation for the delay if you're trying to reopen that case now. If there have been changed country conditions, that can provide an explanation as to why I've delayed asking the court to revisit my case. But on all accounts, it's important to kind of understand what my opportunities are, what my options are, and to investigate the country conditions along with counsel. At this time, we're going to open it up for questions and answers, and I can address those. Let's go to the next slide, Roger. Before we get to the questions and answer, I want to discuss the reason for this webinar and the urgency of this message. On January 20th, we will there'll be a new administration. That new administration has indicated that it will be tough on immigration, that there's going to be increase in detention and increase in deportation. It's extremely important in these upcoming weeks to consult with counsel, to understand what my options are, to understand if there's relief that I can apply for, and how I can best protect myself. Now is the time to get consultation, and now is the time to understand what my records suggest and how I'm going to be, and if I'm going to be affected, and who's going to be most affected. We can open it up to questions at this point.
Okay, thank you, Shan. That was very illuminating. Uh, Let me just stop sharing my screen for a quick second here so I can access the questions that have been asked. Okay, so There's someone who has asked a question who says, I entered the United States when I was only 13 years old. I am from El Salvador. I have lived here for the last 22 years. I have two children and I'm afraid to return. What are my options?
Well, I can't speak about these particular facts of an individual's case specifically. That would require a consultation with counsel so we can understand the facts and the nature of your circumstance. But in but in but this scenario suggests that perhaps they may be eligible for relief in removal proceedings if they've been here for more than 10 years and they have U.S. citizen children or U.S. citizen spouse. There's relief that may be available to them. And it's important that they understand whether or not they meet the threshold of qualifying for that relief. Also, depending on where they're from in the world, they may also have a fear of returning to their home country. And so, in that case, they may be eligible to apply for asylum. So, on that scenario that you described, there are potential relief options, and I would highly encourage them to explore that with counsel.
Okay, thank you, Shan. Uh, those giving us feedback on the captions, thank you. Uh, we were figuring out a way how to do this, and thank you for your help. We will definitely take care of it in the next webinar. We have another question who said, this person says, I am 43 and I was convicted of possession of marijuana when I was 18 years old. Can this affect me? I have a green card.
As I mentioned, when we're looking at individual cases and individual facts require a consultation and a review of an individual's record. However, this scenario presents a very serious issue. Those convicted of controlled substance offenses may be subject to removal. Controlled substance offenses are removable offenses and can have a very adverse immigration consequence. Depending on the nature of the conviction and depending on the age of the conviction and how the person was convicted, they may be able to return to criminal court to get that cleared from the record through post conviction, as I discussed. But this is a very serious matter. And although in certain states, uh, marijuana has been decriminalized, still federally, it's a controlled substance offense. It's a removable offense. So I would strongly encourage someone in that predicament to consult with counsel.
Thank you, Shan. There's one more person who says, is it possible to clear my criminal conviction and reopen my removal case?
Yes, it is. It may be. Um, the law provides the opportunity for individuals to reopen their cases even though they've been ordered removed. That occurs when they're eligible for new relief, perhaps relief they weren't eligible for initially. Also, they may be eligible to reopen their case if they now have a fear of returning. Those types of circumstances require an individualized examination. We have to examine the removal order, examine the record to determine whether or not there's new relief, whether or not there is perhaps um, mistakes in their original removal proceedings, or whether or not they have a fear of returning to their country. So it is very possible to reopen a case, but it requires a detailed and examination of the record.
Thank you so much. We have one more question. We have two more questions actually. Someone is asking that they are a US citizen, but their spouse is undocumented. So what can they do?
Generally, a U.S. citizen can apply for a visa petition for their non-citizen spouse. Uh, there are requirements in there are requirements for the non-citizen spouse how they would obtain residency. Sometimes they're able to obtain residency in the United States by applying for adjustment of status. It really depends on when they enter the country, how they enter the country, depends on whether or not they have a criminal history or not. Also, there are other opportunities to apply for waivers, and perhaps if there's any violations of the immigration law, or they may apply to gain status through their U.S. citizen spouse through consular processing. But the law does provide a way that U.S. citizen spouses can petition for their partners and for those individuals to apply for their residency.
Oh, that's good to hear. That's really good to hear. Shan, there's just last question. Someone wants to know if they can apply for asylum, even it has been more than 12 years.
Yes, when you're applying for asylum, there are different types of asylum protection. Mostly, it's required that when you're applying for asylum, you apply within 1 year from the time that you enter the United States. However, there are exceptions to that rule. What we want to look at is the reason why they have a fear of returning to their country. What are those circumstances? What are the country conditions? And whether or not the country conditions have worsened or changed. Asylum is a very popular form of relief. And if there is evidence of risk and evidence of danger, evidence of persecution, asylum is a very popular form of relief.
So, the person who had asked about the criminal conviction and reopening of their removal case are asking if you can help them clear the criminal conviction and reopen their removal case.
Yes. Initially, what we would do is that we would examine their criminal records. We would obtain their criminal records, examine it carefully. Uh, we would also examine whether or not they fully understood the adverse consequences of their plea if they entered a plea. We would work with the courts and work with the prosecutors to see whether or not there's some sort of mutual resolution. Those initially where we start is in the criminal courts with the records. Then we file a motion with the criminal courts, asking the court to clear that from the record or mitigate that to minimize that. If they've been ordered removed because of that conviction, once that conviction is remedied, we can go back to immigration court and ask the court to revisit their case through a motion to reopen.
Okay, that's wonderful. Now there's someone who's really worried, poor thing. They have overstayed their visa, so they want to know whether they can be detained or deported.
It is possible that someone who's out of status may be detained and deported because they have no status. However, whether or not they'll be a priority for deportation and detention really depends on many other factors, such as do they have a criminal history, uh, when they how long they've overstayed their visa, and whether or not there are any other exigent circumstances. But if you're not in status and you don't have a petition pending that gives you lawful presence, you may be at risk for detention and then possible deportation. So it really depends on the specifics of your case. And what I would advise is that they would explore other forms of relief, other things that are available for them to them in order to prevent detention or removal.
Okay, so what do you suggest? Should they schedule a consultation with you, come and see you, and see what their options are?
Yes, if you've overstayed your visa, I would like to. I, I think it's important to speak with counsel to understand why you overstayed your visa. Also, to understand what other relief is available to you, such as an immigrant visa, perhaps if you have a U.S. citizen partner, or U.S. citizen adult children, or perhaps you can petition for protection in the United States through an application of asylum. But the relief really depends on the specific circumstances for that individual, and to get to the heart as to why they overstayed and whether or not they have some sort of apprehension or fear of returning to the country.
Okay. Thank you, Shan. This has been most illuminating. I think if there are no further questions, then I do have a few more things that I'd like to share with you. So, if you want help, if you're looking for help, please visit www.shanpottslaw.com. On the home page, you will see a blue button. It's right at the top on the right hand side. If you click that, it'll take you to a page where you can schedule a free consultation. We do not charge for consultations. Once you've done that, or you have other options, you can call us directly. Please do make a note of this. This is our number. Don't worry, we are with you throughout the way, and you really don't have to worry. Actually, you've got Shan by your side. He is one of the best attorneys in LA. So please do contact us if you need help. And thank you so much for joining today. A recording of this webinar will be made available soon. So please keep an eye out in your inbox. Just keep a lookout. That will have Spanish subtitles. So okay, so this person is asking, what advice do you think you could give me for these changing situations here?
What situation are we referring to?
That is very vague. I think they're talking about the the whole general scenario for immigrants in the US.
There's after the elections, what I've noticed that there's been a lot of anxieties and a lot of fear. It's a lot of unknown. So, and the most important thing is to understand what your circumstances are. Uh, uh, what in order to get a clear understanding of what the risks to you. Now, the new administration has been talking about what it intends to do, such as deportations and detentions, uh, strengthen border security. But how this impacts an individual really depends on the specific nature of their circumstance. What they should do is consult with an immigration attorney. Let's review your record. Let's see whether or not there's new relief that's available to you and what you can do now to protect yourself and to gain status. Even those individuals who have lawful status, such as lawful permanent residents, we want to look to make sure they're still in valid, that there's been no violations of the immigration law, whether or not they're able to gain greater protection by applying for citizenship through naturalization, and whether or not U.S. citizens can apply for their non-citizen family members. So the new administration has made immigration the center of its platform and its policy decisions. And with that, there are going to be many changes. There are a lot of unknowns. At this moment, what I would suggest is speaking to counsel, speaking to immigration counsel, understanding your record, understanding what options you have, and moving forward with just being aware and being informed and knowing your rights as to uh, how to best protect myself and my family.
That was wonderful, Shan. That was really very helpful. So, if there are no questions, then we will then end the webinar here. Thank you everyone for joining. Thank you so much for taking time out on a Saturday morning. We will be sending out a recording of this webinar with Spanish subtitles very soon. Please forward it to other people that you know. Yeah, so we can reach out to as many people in need as possible. Thank you so much for being here. It was really our pleasure today. Thank you. Bye bye, everyone.
Thank you.